Good morning, everyone, and welcome to the BIASC and BILD State Legislative Housing Tools webinar. We're going to start in just 1 minute to let some additional people into the Zoom call. Welcome, everybody. So we have a very large panel, a lot of information to go over, so I think we're going to get started promptly. So good morning, everyone. I'm happy to be joining with everybody virtually on this really exciting topic. My name is Chagai Mazur with KB Home. I'm the BIA LAV board member. Before we begin, I wanted to thank our 2021 BIA presenting sponsors. I believe we have a slide. Thank you, Diana. So thank you to all the sponsors. Throughout the webinar, I encourage you to use the Q&A function, not the chat function, for your comments or questions. We'll be monitoring that the Q&A section as we proceed through the webinar. So in my role at KB, I'm tasked with acquiring and then entitling land opportunities for residential developments. And ironically, as we face an ever worsening housing crisis, cities have become more averse to allowing zoning changes for residential use. In a time when cities should be welcoming our developments, it's the complete opposite. And I believe the state has recognized that challenge, that cities and counties have been very difficult. And so the state legislature has passed some laws to give us the tools to be able to help encourage cities to rezone properties and to follow their housing elements and general plans. But in my experience, when we use these tools, two things happen. Number one, city staff has no idea what we're talking about. They're unfamiliar with these laws, and so then we have to educate them on how they're used and when they can be used. On the other hand, cities are reticent to use them because they feel that these laws are stripping away from their administrative or ministerial powers. So it's incumbent upon us to become the expert in these laws to make sure that they're being used appropriately. And so I asked the BIA to put together this panel, get some legal minds to take us through the laws, get some case studies, and also have a representative from HCD to hear from the state how they are viewing the housing crisis and how these laws can be used. So with that said, it's a very large panel. I want to go quickly to them. We're going to put everybody's bio in the chat. So I just want to quickly introduce Andy Henderson with Henderson Law Firm. We have Adam Wood with the Building Industry Legal Defense as our Building Industry Legal Defense representative, BILD. BILD is the legal arm of the BIA. I'd also like to introduce Shannon West, the Land Use and Planning Unit Chief for the California Department of Housing and Community Development, HCD. We'll also hear from Nick Camarota, the Senior Vice President and Legal Counsel at CBAA, the California Building Industry Association. And last but not least, Daniel Golub, partner at Holland and Knight, who will be taking us through some case studies of how these laws have actually been used. One of them particularly sensitive or special to me because it was a project I worked on. And so with that, I kind of want to kick it off with Andy Henderson. Andy, you've written a very interesting white paper about housing supply and its effect on the market. And I'm going to kick it off with an open-ended question to you. How did we get into this housing mess?
Well, thank you. I'm Andy Henderson. I was actually in Adam Wood's position as the general counsel of the BILD Foundation from 2005 to 2013. But since then, I've been, I hung out my shingle and I help clients on their projects, but I also continue to do policy work for the BIA on regional planning and VMT and other matters. Back when I was at the BIASC and at BILD, I used to hear quite often from CBIA about how building permits would go up and down with the economy in wild swings. There'd be robust home building and then a recession would hit, such as the one in the early 90s, and home building would just plummet. So when you looked at the trend of home building in California over time, it would look like a sine wave, up and down. But I started thinking, it really needs to be looked at a little differently. We should normalize those numbers against the growing population and then against the growing housing stock. So I started doing that. And when I left the BIA in 2013, I think I had that kind of data from the time period 1954 through 2012. And then I left all that off. I don't think anyone else picked it up. But when the pandemic hit last year, I thought I had a little time on my hands. So I took another look at it, and I was able to determine that actually very good data on both population and housing stock is available for California going all the way back to, well, I went back to 1940. The federal census information is largely based on population and households. So they have very good data. And in more recent decades, the state of California has excellent annual data on these matters. So I put together the data and have a white paper, which I believe is linked so that you can pull it off the chat room or somewhere in connection with this seminar. And I distilled a couple of data points out of that white paper to show you on slides here. Basically, everything in the white paper is derived from this one table, which shows in the left-hand column the population of California over 8 decades, and in the right-hand column, the California housing stock. And so I just use that data to look at averages over time and see what's going on with the growth in housing stock in California in relation to population growth. So if we go to the next slide, you'll see it's really a pretty woeful story in the last 30, 40 years. The nominal housing units added per year continues to plummet. And we were now down into the decade just ended on April 1st, 2020. We're only down to about 70,000 units a year, 68,000 units a year average annual addition to the California housing stock compared to 150,000 average over that 80-year period. And the next slide, I think, shows a graph of the same data. And you can see it's really plummeting. Ironically, the best year for housing production was 1963 in California. The year that President Kennedy was killed. And certainly on a normalized basis, it's been going way down ever since. So let's move on to the next slide. This shows the California housing unit growth in relation to population growth. And here again, you see in 3 out of the last 4 decades, we've been adding to our housing stock in lesser amounts than the population has been growing. And in the decade just ended, population actually grew at about 6.85% over that decade. Housing stock only grew 5%. And that's also reflected on the first table that I showed you. And that's just unsustainable. You add to that the fact that households continue to shrink in size. The more affluent people continue to own second homes. And it's a formula. This is a pattern that leads to the kind of homelessness that we now see. And we really, really, really need to get these numbers going in a different direction so that the growth in the housing stock is keeping up with or exceeding, given the backed up demand, is exceeding the population growth, and we're nowhere near there. So what I then did is not just look at the nominal numbers, but this is what the chart looks like when you normalize California's housing stock over by the population over time. And basically it shows the number of housing units added per year on average in these decades in relation to 1,000 population. So in the early years, the 40s and 50s, it was roughly 14 units per 1,000. It peaked in 1963 at 18 units per 1,000 for that 1 year, but now we're less than 2 units per 1,000. So we're building at a rate in relation to our population of about 1/7 or less of what we were building at in the post-war years when we were growing from a smaller base, but California was really adding houses, and more so, much more adding more houses than population growth would indicate. And then the last slide is this one, which shows the same data, but normalized against the housing stock at the time. So back in the 40s and 50s, we were adding annually over 4% to the housing stock annually in California. Now we're down to less than 1/2%. So at that rate, it would take 200 years of building to basically double our housing stock. We're at 68,000 units a year. If you recall, Governor Newsom, when he came into office, said he wanted to see 3.5 million houses built in California by 2025. You know, that the likelihood is we're going to be less than 20% of that during that time period. So California's housing production is woeful. It's ever worsening, and it's really bleak. So as we talk about laws to allow a building to go forward, let's keep these numbers in mind. The BIA will continue to track these over time, I'm sure, and we're doing everything we can to reverse these trends.
Thanks, Andy. And I think this is one of the reasons, SCAG and the state has really been pushing to produce additional housing. And we see that with the RENA numbers and kind of with the sixth cycle of RENA coming out and cities having to update their housing elements. I was hoping to talk to Adam about BILD a little bit and kind of give us an insight on RENA, the future of RENA, and kind of what BILD has been doing with these numbers and working with cities.
Yeah, appreciate that. Thank you. Again, Adam Wood, Building Industry Legal Defense Foundation. Andy's presentation is, really why we're all here today. I mean, the numbers are staggering. This chart is incredible. It's getting harder every year to build housing in California, and that's why the BIA and BILD are here. We're here to help anybody who's out there trying to reverse this trend, and let's get some units built. The numbers to overlay on what happens when you have a graph like this to the supply and demand. In March, it was a 24% year-over-year increase in the average home price in California. We hit $758,000 according to Department of Finance, which is atrocious. How should a family starting out be able to afford something like that? So obviously, great changes are needed. And that's why a couple of weeks ago, we did our first in the series of these webinars focusing on RENA. That presentation was largely focused towards our friends at cities and counties and some of the tricks of the trade that they could use to meet their really, truly historic planning requirements that are coming up between now and October. We had some really good progress on that, but we wanted to continue the conversation today with a much stronger focus on what the BIA and the builders can do to actually start getting to production. And that's why you're going to see some really exciting conversations about the legislation that's come out in the last couple of years that really gives us the tools we need to start turning the tide. And there's really nobody better to sort of tell us what the state's been up to than our next speaker, but I think Hagai gets the honor of that introduction. So I'm excited to be part of this panel, and we'll join you in a little bit for a chat on SB 35. So Hagai.
Thanks, Adam. And so obviously, Shannon, no pressure, being the one state representative having to solve this really large housing crisis that we have been facing, and it's getting worse. Can you kind of take us through how the state has been tackling this problem, the state's mindset, and kind of the state's overview of one of the main tools that we have been able to use, the Housing Accountability Act?
Sure. Thank you so much. Again, I'm Shannon West. I'm the Land Use and Planning Unit Chief here at HCD. I'm pleased to have the opportunity to speak to a virtual room of builders, because as you all know, you're where the rubber meets the road between our good planning and actually building units, and we respect that so much. I'm here to make you aware of some of the tools and services HCD has available. Next slide, please. Before I get started, I really just like to share our mission. We are really a mission-driven department at the state, and our mission is to promote safe, affordable homes and vibrant, inclusive, sustainable communities for all Californians. There's a lot of values packed into that statement, but our vision is also for every California resident to live, work, and play in healthy communities of opportunity. This is the frame within which our work begins and ends. As you might expect, we have multiple stakeholders, including local governments, housing advocates, and builders, and unsurprisingly, not all of them agree all of the time. This is our touchstone for how we view our work and view our role in solving the housing crisis. Next slide, please. So again, I manage the land use and planning unit. We have a number of core duties, but I think the ones that you're most interested in today are the Accountability and Enforcement Authority. But I do want to touch on our duty to review and monitor implementation of housing elements just briefly. We review all 539 California jurisdictions. They are diverse in the state, and every city, county, or city and county is required to submit a general plan, but the housing element specifically comes to HCD for our review. I have a staff of trained housing element reviewers who are looking to keep cities accountable to state housing laws that are ever changing by our well-intentioned legislature. So how do we, next slide, please. How do we talk about our accountability and enforcement work? So today's webinar includes the Housing Accountability Act, SB 35 and SB 330, which is why they're highlighted on this slide. But I do like to give a little bit more context to that. AB 72 was also passed in the 2017 housing package, and it includes authority for HCD to review any action or inaction that a local government makes that is inconsistent with their own housing element. The Housing Accountability Act, Density Bonus Law, No Net Loss Law, and Anti-Discrimination in Land Use. Those are also tools at your disposal, although not ones that we're going to dig real deep on today. Next slide, please. So what is our approach? To be frank, it's been a work in progress for the past 2 years. Our team is growing both in terms of number, but also our understanding of these statutes and how they can be applied. Our approach is always education first and escalation when needed. Not all, but many of our tips come from developers or builders. And when we do an initial review of every request, our initial position is just neutral fact finding. We have a duty to uphold state law, so we will begin by contacting the complainant. We will contact the jurisdiction, and if there are other relevant parties, we'll make sure we get all perspectives. Sometimes we can resolve a matter with simple technical assistance. Sometimes we're able to just pick up a phone and call a planning staff member and explain something in state law that maybe they didn't understand. And that is as easy as it is, and we can resolve it. Unfortunately, not everything is that easy to resolve, and we can march through the steps, right? We have a technical assistance can come in the term of a formal letter. We also write notices of potential violation. That's a circumstance where maybe we know that a city is, say, considering a state density bonus ordinance that is inconsistent with state law. We can let them know in advance, if you adopt that ordinance, it will be in violation. If we find out after it's occurred, naturally that's a notice of violation. But all of this marches down toward decertification of a housing element. We have the authority to decertify a city's housing element, and that is a heavy consequence for cities that are relying on certain state funding resources that require housing element compliance just to apply. And finally, our option of last resort is referral to the Attorney General. I really like to emphasize that this is our option of last resort. It takes a long time. It costs money. It does not get housing units built as quickly as being able to resolve something earlier in this chain of escalation. But it is within our authority, and we have used it. Next slide, please. So these are just a few of the guidance and tools that I think are pertinent to today's topics. Some of these links I hope will be available to you in the PowerPoint that you can download. You'll find other tools within these links, but the Housing Element Portal is what it sounds like. It's a place where you can access all of the local government housing elements that have been submitted to HCD. You might want to do this because perhaps your project is a listed site in a housing element, and if it is, HCD has a lot more enforcement authority over those sites than we do sites that were not identified in the housing element. We also have our accountability and enforcement letters available on our website for you to view. The ones from 2020 and forward are available for immediate download. Earlier ones are available upon request. Our housing open data tools, I could talk about them for a long time, but I promise I won't. I'll keep it short. The SB 35 and SB 330 maps are probably the most important tools to today's conversation, and they're available at the link on the screen. Finally, I did want to share, we have Housing Accountability Act Technical Assistance Advisory, and we call it the Streamlined Ministerial Approval Process, or SB 35 guidelines, because it turns out that these bill numbers are recycled every year. So that was really handy to call it the SB 35 guidelines in 2017, but today not as much. Next slide, please. So finally, I think you're probably interested in how to enlist the help of HCD. So this is the main way to submit a potential violation. You can do that by email, compliancereview@hcd.ca.gov. A quick note, all comments submitted to HCD are subject to the California Public Records Act. We understand political sensitivity that you're juggling when you reach out to HCD for assistance with a local planning matter, and you want to maintain your relationships and continue working in these cities. We are sensitive to that. We can hear you out without contacting a jurisdiction, but it will limit our ability to intervene in a really formal way if we're not able to hear both sides. But I do like to say, please feel welcome to reach out to us. We will go as far as you want us to go. We will stop, I should say, if you really want us to stop, if you feel like we're making it harder for you. Next slide, please. So we're getting down to the end. I just want to make sure everyone is aware. You can sign up for emails from HCD. Why would you want to do this? We issue technical guidance, we draft that guidance, and we invite public comment. And honestly, you are some of our biggest stakeholders. We really, truly invite your participation when we open those comment processes up to the public. Next slide. Again, we're on social media. HCD is active on Facebook, Twitter, and LinkedIn, and Housing Twitter is on fire all the time. I think you all probably know that, but please follow us. And finally, one last sad plea. I know I mentioned that our team is growing. It really is, and it is such a challenge for us to find qualified people who want to do this work on behalf of the state. If you know people who are interested, who you think have the right experience and could help us solve this housing crisis with you in partnership, send them to jobs.ca.gov and tell them to look for jobs at HCD. We actually have brand new positions posted today in the accountability and enforcement team. So thank you very much for the opportunity to share with you some of what we're doing. Guy, I'll toss it back to you.
Thanks, Shannon. Great presentation. I know that those links that you provided are going to be definitely used today once we get this PowerPoint out, because it's really important for all developers and builders to utilize the tools that the state provides as our entitlements are getting more and more difficult. And so now I want to turn it over to Nick with our partner organization, CBIA. Nick's in Sacramento. He's close to these laws. He's working with the state legislature. Nick, kind of take us through how these laws came to be, the origin, why, and some more information from your close contact with Sacramento.
Thanks, Guy. Well, I wanted to focus principally on the Housing Accountability Act, which also goes by perhaps a less formal name, but equally as fitting to it, the Anti-Nimbi Law. And I think this provides some protection to developers and home builders in order to kind of curb the ability of local governments to either deny a housing development project, or to reduce its density, or to otherwise make it infeasible to do the development. And along the way, I mean, we're using terms that may not have the common name of it, the common notion of what a housing development project is. It's obviously residential units. This is defined in the statute. It includes mixed-use development where 2/3 of the square footage is residential, and it also includes transitional or supportive housing. And there are, as this is one example, but there are lots of defined terms in here that I think provide some benefit to folks when they think about reducing density. Lowering density is also a defined term in the statute, and that includes doing things that would impact the project's ability to provide housing. And that's something to keep in mind as you're trying to apply this. I should say that it doesn't. There is some qualification on what a housing development project is, in addition to those three categories that I just mentioned. It has to comply with objective, either general plans, all three of these general plan standards, zoning standards and subdivision standards. And interestingly enough, objective is, and I'm going through this because we had battles over all of this, and it was informed by experiences that people were having out in the field. I mean, this is a statute that's been on the books initially since 1982. And so we have some experience with it, and it simply wasn't delivering on the promises that the legislature intended. And so I think beginning back in 2017, we started to kind of tighten, I hate to say tighten the noose, but tighten the flexibility that local governments had in denying or reducing the density or otherwise rendering infeasible a housing development project. So here we had to go through the trouble of saying, what does objective mean? And we explained, or we defined it in statute by saying that it involves no personal or subjective, judgment, and it could be verified by some reference to some independent benchmark or criterion that was knowable not only to the guy behind the counter who works for the city or the county, but also to the development applicant, the proponent, so that we could point to it instead of being subject to this subjective interpretation of whoever it was we were talking to at the city. Now, when I said it curbs their flexibility to deny, et cetera, projects, it doesn't completely eliminate it. It means if you're going to do this, if you're going to, let's say, deny a project, you have to make findings. And among those is that you have to find that it has a specific adverse, unavoidable impact on public health and safety. Again, what had started out being in the body of the bill, we had to move up to the intent, but impacts on public health and safety are intended to be infrequent, because there was a lot of abuse that was going on out in the field, at least from our perspective, a lot of abuse that interpreted public health and safety as pretty much everything that commensurate with the police powers that local governments have.
I know, Nick, not to interrupt you, but I also think that, Dan can kind of speak to this perfectly about how to use, so the law is great, but let's see how it's actually used in everyday interaction. So Dan, this is a great law. How have you used it?
That's a great question, a great transition. I hope everyone appreciates how much work the CBIA and Nick specifically do for the interests of the building industry, the building industry as a whole. You may not know everything they're up to in Sacramento. It is not always an easy place to get pro-housing legislation on the desk of the governor and signed. And yet they have, with a broad coalition of people who want to see housing built, gotten a lot of really important bills passed. My name's Dan Golub. I'm a partner at Holland & Knight's West Coast Land Use and Environmental Group. And if Nick and CBIA are the midwives who help bring these laws into the world, I guess I'm one of the people who tries to raise these children so that they grow up big and strong, which is to say I invoke these laws on behalf of project applicants. And if I can't successfully invoke them in the entitlement process, I litigate these cases in court. So if you go to the next slide, and the next slide. Again, Nick points out it's been the legislature's intent for some considerable time to meaningful curb the ability of local governments to deny or disapprove housing. And if you go to the next slide, I won't spend too much time on this, but this is the basics that Nick just laid out there. This is not a new law. It was enacted in 1982. In New York, where I used to do planning work, if you submit a project that complies with the general plan and zoning, you just go get a building permit. It gets reviewed for technical standards, but it doesn't go through another discretionary process. I tell my friends in California this is how it works, and they're stunned because, of course, in California for many decades, we've been wedded to the notion that local governments will engage in use permit or other discretionary review, even when the project fully complies with objective standards. Since 1982, the legislature has been saying, look, if people want a zoning change, that's one thing. But if a developer wants to build what the city's own plans call for, shouldn't you be approving it most of the time? I mean, with an exception for public health and safety. And so the HAA for some time has said that there's two independent categories of projects that are protected. First, projects that apply with objective standards. There need not be any affordable units. And then there's a second and additional higher level of protection for projects that have at least 20% lower income or 100% middle or moderate income. So that's the background, but Hagai's question wasn't about the background, it was about how we've used it. So let me run through a couple quick case studies. And Hagai knows this one. This is the easy way, where we try to invoke the Housing Accountability Act through the entitlement process, make sure the locality is aware of the limitations that are imposed by the Housing Accountability Act, and get an entitlement out the other end. This is an example of a 2020 project that we worked for the Olson Company. Hagai was then working for them. KB Holmes has the pleasure of his employment now. But we basically just wrote very strong letter. Hagai came to us and said, I don't think they totally know all the limitations that are imposed on the HAA. Can you write a letter? Can you engage with staff and help explain that? And we find that successfully helped the city understand that they had discretion maybe over conditions. They had discretion if they wanted to find a public health and safety problem. But other than that, they should approve the project, and they did. The next slide is if we had to go the hard way. And here's an example of sorry, phone's ringing, can't always control that. And here's where we had to go the hard way. We had a project that was a 389 unit multifamily rental housing development, 20% low income. So we thought we were doubly protected by the HAA, was consistent with objective standards, but it was also had qualifying amount of affordable housing. We got denied. We didn't think that there were any valid grounds to deny consistent with the Housing Accountability Act. And they refused. They had a process where there were these subjective allotments for housing, all allotted on the basis of purely subjective criteria about whether you could build in their community. We filed suit. We reached a settlement about a month later. We submitted a proposed judgment to the court in which said, all parties agree that this was not a lawful act under the Housing Accountability Act. And they had approved the project by that October. So that's the hard way. And then last slide before I turn it back to you, Hagai, important case to watch, which I'm representing now. I'm representing the California Renters Legal Advocacy and Education Fund. We call them CARLA. They're appealing a decision we got from a trial court suggesting that these laws are unconstitutional. We don't think that's right. And so we've taken the question up to the first district, and that's a case to watch. We think these laws are valid. We think these laws are constitutional, and I'm fighting the fight in the Court of Appeal to hopefully get some published case law that furthers that view.
Thanks, Dan. Well, thanks for writing the letter, in La Mirada, which was very
You're
helpful.
welcome.
One thing I did with that letter is I let the city know it was coming. I didn't just slap it in front of them and say, "Hey, here you go. You have to use this law to our benefit." I let them know, like, "Hey, I don't think you're interpreting the law correctly. Let me help you understand the law better with this very well and somewhat strongly worded letter that's going to explain step by step how the law is meant to be used." And although it wasn't taken, very well in the beginning, it did what it needed to do to get the project entitled. So that's Housing Accountability Act. The other big buzzword or law that you hear thrown around is SB 330. And so that is another law and tool that we have at our disposal to start getting these projects approved, hopefully faster when there's a difference between the general plan and the housing element, and they're not aligned. And so, Andy, I was hoping you can provide some background with SB 330 and how it's used and how it can be an effective tool for entitlement.
Yeah, glad to. And I'll turn it over pretty quickly to Daniel to talk about case studies. But the Housing Accountability Act that Nick and Daniel just discussed has been amended like countless times since 2016. In 2019, SB 330 was passed, and it did a number of things, including it put in place the Housing Crisis Act. Probably the biggest change that came about in SB 330 is a pre-application mechanism where a developer can put forward to the city or county a pre-application for their project that includes certain specified information about the site, such as how many units, residential units you're going to demolish, and certain environmental concerns, and public easements where they're located on the property site, And if you're in the coastal zone, which it means you're both crazy, and there's additional considerations you have to have in your pre-application. But you put that in, and then you put in certain information about your project and whether and the extent to which you're going to be taking advantage of density bonus law. And once you get that in, it basically freezes in place all of the city's requirements for the application that will follow. It requires the cities to have a checklist on their website of the application requirements for your project, and you have 180 days after you do your pre-application to then get your application in under this scenario where requirements are largely frozen. There's a couple other elements of SB 330. One is that it limits the number of hearings of any type that can be held after you get your application in. And then there's also an element of the statute that affects what they call affected cities and counties, which are largely the urbanized areas, and puts on hold until 2025 any kind of moratoria, and otherwise makes it harder to sort of do anything except in a true emergency that would arrest home production. And it's also got a no net loss provision, but as was mentioned earlier, there's been no net loss provisions in the law for quite a long time, and they were beefed up in 2017 to include no net loss provisions that relate to the allocation of housing units by income level under RENA. So no net loss has been around for a while, but this 2019 SB 330 sort of reemphasized that with respect to affected cities and counties. So with that, I'll turn it over to Daniel for some real examples of how you can use this new law.
Well, thanks, Andrew. This is the list of what Andrew just said, which is that there's an option to submit a preliminary application, and you're deemed to have submitted a preliminary application once you've submitted the following list of information. For many people who have already gotten very deep into the planning process, you may already have submitted a preliminary application because all of this material was already in your application. So for project applicants who are already at that phase, it might just be time to remind the city that at this point, your rights are vested. And that's a right to be vested against zoning changes and general plan changes, and explicitly a right to be vested against later increases in development impact fees, which of course is a big thing that has been a project killer for many projects. So either you've already are deemed to have submitted a preliminary application because all this material has been submitted. In most cases, you may have already submitted all of this material to the city. If not, you might want to get together a preliminary application to vest those rights now. The next slide is just a summary of what Andrew also said, which are the other provisions of SB 330, prohibitions on downzoning, prohibitions on how many hearings a locality can really make you do after you have a complete application. I actually did not put together a list of very specific case studies because I have to tell you, since SB 330 took effect, I've invoked it in every project I've worked on. Unless the project needs a general plan amendment, a zoning change, or something like that, you're likely to be protected by SB 330. There's very little downside to invoking your rights to be vested against future changes. It can sometimes be a complex analysis. Once you submit that preliminary application, there is, for some reason, a requirement that you get your actual application in 180 days later. So you might want to make sure your ducks are in a row. But I think it provides really valuable protection, both for projects that are already in the application process, that you've submitted your full application. You want to make sure you've vested your rights, as well as for people who haven't yet gotten to the point where they've submitted a full application, but you want to be vested before that. And you can do that with SB 330's vesting protections.
And just a quick question. I know this has happened in the past. Sometimes cities will update their zoning or their housing element. But they don't do the, also the change to the general plan to reflect those changes. So you have a discrepancy between the general plan and the housing element. Can SB 330 be used in that case?
There are a lot of really good housing laws that we are using to that effect. I'm actually not sure, I don't believe they necessarily took effect through SB 330, but there's amendments both to the Housing Accountability Act and the Density Bonus Law that have really pushed a point, again, a CBIA priority, which is that to the extent you've got a general plan that objectively commits the city to allow housing at a certain density, but the zoning just hasn't been updated. The general plan, of course, is supposed to be the higher authority on these points. And there's a lot of several revisions to the HAA and the density bonus law that say that quite explicitly. We've gotten great technical assistance memoranda from HCD, and Shannon is instrumental in all of that, helping to explain to cities why that's the case. A city can't tell HCD and the world that you're zoned and that they're going to build densely at 60 dwelling units per acre in their general plan, and then tell a housing applicant when they'd like to use that density, oh wait, the zoning doesn't allow that. There's laws that we can use to invoke to get around that problem.
Thanks, Dan. I'm not supposed to ask questions in the middle of the presentation, but I had to get that one out. So the last law that we wanted to cover is SB 35. Now, traditionally, and Adam, you're going to be going into those details. Traditionally, SB 35 was not something a for-sale home builder thought we could use. It was more geared towards the multifamily space. But I think that you're going to see some of us changing our approach to that. And so, Adam, take us through SB 35, and then I can discuss why I think that the home building world might have some use from it.
Yeah, thank you. To your point, yeah, it hasn't quite made its way to Southern California yet, but it's starting to get some traction up north, and Dan can certainly give some really good examples of that here in a second. But SB 35 is approved back in 2017 to streamline affordable housing, specifically designed to create a streamlined approval process for developments in jurisdictions that really haven't met their housing requirements. And what exactly that means, kind of technical, HCD maintains a list, and we can send you the website that lists out who's in and out currently on that list. But how does it work, generally speaking? There's a lot of requirements that we can dive into, but I'm just going to hit on a couple of the highlights in the interest of time. Developer brings a project with affordable housing, somewhere between 10 and 50%, depending on a few of the technicalities behind it. Project has to be an infill project. And what's really slowed down its use in Southern California, I think, is that it also has to, all the workers on the project have to be paid a prevailing wage. There's also a skilled and trained workforce requirement on it. And I know that's created some real challenges to get projects to pencil that maybe the math's a little different up north. So I think the tide might be turning on that, but the reason that this is a fantastic piece of legislation is that if you can find a way to work through some of the complications, you get a ministerial approval process within 90 to 180 days of submitting. They can only review objective standards. There's no CEQA involved. And there's built-in limits on parking and some of the other requirements. So it's a little bit of a golden goose if you can make it work. And nobody's been better at making it work than Dan. So I don't want to fill up too much more time on the background. Let's hear about how this has been working.
And Dan, sorry to interrupt you. I encourage the participants on this webinar, please start using the Q&A function for your questions. We're going to try to leave some time at the end. And so, Dan, you can go ahead, but I'm going to start reviewing those questions now.
Sure. Well, thanks, Adam. I appreciate that. The math's the same up here. Committing to a high level of affordable units and committing to prevailing wage costs projects significantly. And some projects just look at this idea and can't pencil. What I would just encourage you to think about is what Adam just said, which is if we're talking about a ministerial CEQA exempt approval within 90 to 180 days, and especially if you're in a jurisdiction where you think your entitlement process is going to be much longer and much more costly than that, you should just think about whether SB 35 might have some options, especially in the jurisdictions that are subject to streamlining with projects that only require 10% affordable housing. In hotter housing markets where it's a 50% affordable housing target, that might not be achievable, but I'm going to tell you one project that did. So here are some examples, if I could see the next slide. First of all, there's the, I'm sorry, go back one more slide. We usually try to do this the easy way. Again, we have had SB 35 applications approved and in process in many cities. I do tend to work in the Bay Area, but we have definitely handled projects in Southern California as well. And I'd love to handle more if you have some interest. It does tend to be used by the 100% nonprofit affordable housing building community. Why? Well, they already meet the affordable requirements and they might be doing prevailing wage anyway because of public funds. So we do see that used a lot by the 100% affordable community, but there are projects that have used it who are from the for-profit world. And again, we've done many of these through the process. There's also always the option of saying, look, we could submit an SB 35 project, city. We think we're entitled to, but if the discretionary process keeps rolling along in a way that produces housing, we won't do that. And that can sometimes be an incentive for a city to work things out through the discretionary process. So that's the easy way. I've done it twice the hard way. And if you could see the next slide. So in the city of Los Altos, which is in the Silicon Valley, I represented clients 40 Main Street. This was the first decision ever to find that SB 35 compelled the city to approve housing. We submitted a ministerial approval application. We qualified. The city got back to us with a denial that for many reasons we felt was not a valid reason to deny the project. Now, normally you go to court and you tell a judge, hey, my project's been denied, and the court says, I defer to the city, of course, about whether your project was entitled to approval. I'm not going to find that they had a duty to approve your project. But SB 35 creates a ministerial duty to approve your project if you satisfy the standards, and we did. They found that their denial, this was the Santa Clara County Superior Court. And one of the critical factors, and I'm going to give Shannon a shout out as well, is that HCD wrote several technical memoranda to this city saying, this project qualifies for SB 35. The reasons you're articulating, city, for rejecting it are not good reasons, and they won't stand up in court. I tried to tell the city that on a number of occasions, and I brought HCD's letters. The city decided to deny the project anyway, and Shannon was right. HCD was right. And I think the court took seriously that HCD, well, so now Shannon's laughing at me, but it was, those letters were right and they were meaningful in the litigation process. In the end, the court found that the city had violated SB 35 and the Housing Accountability Act by denying the project, and the court ordered the project approved. The ultimate result was that we ended up getting about $500,000 back to pay for my attorney's fees, so that the applicant was not forced to spend the money to enforce what should have been required to be issued in the first place. And we additionally got another $500,000 in damages when the city improperly tried to appeal the decision without posting a required bond. And that project has been approved and the appeal was dropped. So then there's the second time. Next slide, I'm sorry, Diana. And then just last week, we have the first published decision of the California Court of Appeal affirming SB 35. The opinion's not final, but it is a published opinion, and it was issued last week. This was a decision, this was a project we worked on in which the city of Berkeley had denied a 260 home, 50% low income project. And we did lose that one in the trial court. The trial court had said, well, it certainly doesn't look like this project should have been rejected, but I have to defer to the city, as I said, because their decision was not entirely without evidentiary support. That's the traditional standard. You try to litigate against a city, you get this very deferential standard. And the Court of Appeal just last week said that is not the proper standard when enforcing a housing law such as this one, that it would be effectively nullify what the legislature is trying to do. So the Court of Appeal affirmed that we were entitled to ministerial approval for that project too. And also rejected a multi-pronged argument that city argued that this law is unconstitutional, that it interfered with charter cities' home rule doctrine affairs. The court rejected all of those arguments as well, and said that this law was intended to produce housing and it should be interpreted to have its intended effect. So very proud to have worked on both these cases. So that's the first decision by any court to find that SB 35 compelled the approval of housing. And now we have the first published opinion from the Court of Appeal affirming that SB 35 compels the approval of housing. And those are the two case studies that I have. I've got a few more in process.
Thanks, Dan. And as cities are updating their housing elements to meet these very high RHNA numbers, I think there's going to be more opportunities to use some of these laws. The challenge that I have had personally is that these projects I work on, I call it's the full menu of entitlements: the GPA, zone change, variances, the whole thing. But cities are going to have to upzone some sites that were not thought previously as to be a residential site. They're going to take commercial sites and make them residential to meet these numbers. And I really feel that we're going to be able to use these laws far more effectively once these housing elements get certified by Shannon and her team going forward. So I think, Dan, you have some final slides kind of to put all of these laws together and kind of help us differentiate when we can use certain laws and how they are different from each other.
Sure. So this is just a sort of sample idea of how we try to put entitlement strategies together. Again, with the hope that we don't end up in court, but with the preparation that we need. I just have some takeaways. Try to proceed in good faith. That's what we did in the Los Altos case, and it felt like the city didn't, and I think that ended up mattering to the court. You want to carefully review and confirm that you're consistent with your locality's objective standards. Go on that website and check to see what the status is of that jurisdiction. If you're in a jurisdiction where you can do SB 35 with 10% affordable, that might make a big difference to your project, as opposed to if you're in one of the jurisdictions where you need to do 50%. We haven't talked about the density bonus law, and we're not going to. There's too much to talk about, but I use it carefully with all of these laws. Know the differences between your city staff and your elected officials. Work with the Yes in My Backyard movement, who we worked with very closely in the 40 Main Street case and who I'm proud to represent in the San Mateo case. Work with HCD. If I haven't given you enough reasons to work with HCD and Shannon hasn't given you enough reasons to work with HCD, I can't imagine what more we could do. They were instrumental in many of these housing approvals. And like I said, give the city options. Like I say, sometimes you hope that all of the options involve the approval of your project at the end of the day, but there's a lot of different ways to get there, and there's no reason to trample on local government authority except where necessary to get the housing approved. So the next slide. Are we frozen? So this is just, I've sort of mapped these strategies together. SB 330, HAA, remember the HAA has two prongs. One requires affordable housing, but the other does not. And SB 35. So SB 35 requires affordable housing. The affordable housing prong of the HAA requires it, but the other prong of the HAA doesn't. Do you get streamlined processing? Well, only from the SB 35 project. HAA projects, if they're not covered by SB 35, are still the standard entitlement process, but there's a limitation on local authority to deny. Most of these projects, laws are designed for projects that comply with objective standards, but there is an option under the HAA's affordable housing prong to make an argument to advance a project that doesn't conform in all respects to every objective standard. And then of course the biggie, is there a prevailing wage requirement? Only for SB 35. The other processes don't require that. So we try to line up your interests and your goals and see which of this mix and match strategy we can do for you. And then the last slide, I think, is just a sample entitlement sort of pathway I walk through when I'm trying to invoke these laws. I try to assess the permitted density. That's step one. Think about the density bonus law. And as I mentioned, and I think a guy asked about a little bit earlier, effective in 2019, you can invoke a general plan density even if it's inconsistent with the zoning. Step two, think about your preliminary application with SB 330, vest your rights so that those fees don't go up. Step three, consider how you want to invoke the Housing Accountability Act to make sure that the city knows the limitations on its discretion to deny your project, denote or reduce the density of the project, and back to Nick's point, or impose any other condition that would effectively reduce the density of your project in its ability to provide housing. And then step four, it's not going to work for every project, but I do encourage you to think about it. If your project can prevailing wage and it can meet the objective standards and the affordable housing, you should think about whether you might want to design an SB 35 application.
Thanks, Dan. And one thing I see, Andy.
And then,
yeah, go ahead. I'm sorry. Go ahead, Dan.
No, we have a housing handbook. It'll be in the slides if you're interested. And then I think the last slide was just how to get in touch with me if you're interested in learning more about these laws or how they might affect your project. I'm very happy to talk to any members of BIA Southern California.
Thanks, Dan. Very informative slides. I think that last, graph that you put together was great. One thing, I think from the builder standpoint is we've been always hesitant to talk about prevailing wage because of its cost aspects, and it's not. We don't really use prevailing wage currently in many of our projects. That being said, the risk that you lose going to this ministerial process, risk is costly, and so we can look at what is the cost benefit analysis of going through an SB 35 if the affordable requirement is nominal. Maybe it does actually pencil out for a certain project. So quickly, Andy, I know you had your hand up. I'm gonna shoot over to you, and then we're gonna go to the Q&A.
Yeah, I see there's some questions building up, and maybe some are better for Nick to respond to there. But I had a question about the SB 330 and the 180 days, Dan, for you, that I hope you can answer. You said that sometimes people sort of accidentally pre-apply and don't know it, and yet you've got 180 days. What happens if you blow the 180 days, either by accident or on purpose? Does the sort of vesting roll forward to 6 months prior to a complete application, or what happens?
Yeah, so I don't know, because I'm not sure that's exactly happened, but it's a good point. There's a requirement to get your complete application in within 180 days of having a preliminary application in. But the law clearly provides that you're vested either when you have your complete application, like all the planning work, or your preliminary application, whichever comes first. So that's an important thing to bear in mind. If you already have your complete application on file and you've been deemed complete under the Permit Streamlining Act, you're vested under SB 330 anyway. The preliminary application is generally designed for people who aren't that far along in their process, and they want to vest before they get their planning application in. If you want to follow that kind of process, you submit the freestanding preliminary application using a form that HCD has prepared. Use the HCD form, unless the locality has a form. But if you use the locality's form, double check that it's consistent with HCD's form, because it might not be. And the law is clear that city can't put any additional requirements in that form. So you're going to want to just, Andy, I can't spell out sort of every single chronology that might happen. I actually don't see anything in the law that doesn't stop you from just submitting another preliminary application if your 180 days is coming up. I think that to the extent you've submitted a freestanding preliminary application and you don't get your complete application within 180 days, you might lose your vesting rights as to the old date, but you might want to submit a new one.
Very good.
Thanks, Dan. So we do have some questions. I think this first one is going to be for Nick. So it's from Christine. Great presentation. Thank you. Thank you for Christine for joining us. So many jurisdictions have had land environmental issues, USCs in particular. Will the state make provisions and brownfield funding available to help local jurisdictions or developers clean up land? Have we already tried to push for this type of support?
So I'm not aware of this actually being something that the legislature is considering or is being considered as part of the budget process. I will say that what we are following very closely is new guidelines that is coming out of DTSC and the State Water Board regarding vapor intrusion, which is definitely something that affects certainly infill areas, but even some other areas that you may not think have this problem. Vapor intrusion is simply these volatile organic compounds that escape from the soil because there are toxics either in the groundwater or in the soil itself. And they are really ratcheting up on the stringency and the parts per billion, et cetera, of various toxic chemicals that vaporize. And the concern here is that obviously with housing, you have people living in these structures. Somebody opens a window or it comes up through a slab. What are you going to do? And frankly, what's the liability on on the developer there, because these can have long-term health impacts on the occupants. And what are the mitigation measures? Do you have to pump up all the groundwater that's contaminated, which, as you know, probably comes from offsite? I'm sorry, I'm getting probably way too complicated for this particular item, but simply to say that's the thing we've got our eyes on. And it's something that, even though it's called guidance or guidelines, it's really being something that the local regional water boards are picking up on and going with, even if it's not a regulation.
Thanks, Nick. A question from an anonymous attendee. How much additional time did the litigation cost the projects? I think that's a question for Dan.
So about 1.5 to 2 years. And of course, that's part of the problem here, which is that we don't want to end up in court. It's not the best result for your project. And usually the incentive on the city, even if they kind of think they're wrong, is the developer's not going to spend 1.5 years in court trying to get this project approved. It's going to kill the project while they're waiting, so I can do whatever I want to them. All I'll say is this: the Housing Accountability Act has some very powerful tools to try to reduce that asymmetry of bargaining position, which is to say that the city bears some real risk to pay attorney's fees. And in my 40 Main Street, there's also a provision in the Housing Accountability Act that makes the city put up some money if it wants to appeal an adverse decision. It doesn't mean they can't appeal. Of course they can appeal, but they owe your project for the time that it takes to appeal. And that's a critical litigation tool that I use and have used. So I'm not saying you want to be in court. You don't want to be in court. If you're being treated in a way that violates the law, however, you have to at least have a credible threat that you would go to court, and to not have the court system bleed you of the effect of these state housing laws. And while it's not perfect, a lot of the revisions, especially the ones that CBIA has fought very hard to get into the Housing Accountability Act, do help with that problem.
Sorry, I'm muted. Thanks, Dan.
Sure.
Another question, and this is one that I actually had too, from Kate. How did the process go for the skilled and trained workforce? How is that defined? We all have trouble with trades meeting apprenticeship and graduate requirements, especially carpenters needing 60% apprenticeship grads on site. I'm gonna throw it up to the entire panel, some more information about that, that workforce training program. Anybody want to take it?
I'll take a stab at it.
Sure.
On skilled and trained, you know, there's prevailing wage, which is, I think, the minimum. Skilled and trained means that you have to be a graduate of a Department of Apprenticeship Standards certified apprenticeship program. I'm aware of one merit shop apprenticeship program in the state, and that's for, I believe it's an electrical trades up in Northern California. It's not impossible to get apprenticeship programs approved, but for the most part, the labor unions control the ability to get approval. And so, having said that, the difference between prevailing wage and skilled and trained is that skilled and trained, you're really getting union members. And because it narrows the field of competitive trades to bid on these projects, and in some areas, there's only one trade who can meet the requirements. And so they basically have you over a barrel, and they know it. And so the amount of money that they charge is really exorbitant. It's not just the difference between prevailing wage and market rate wages. So it's just expensive, a lot more expensive.
So it would seem to be in that situation, you would just go to a union operator for that particular trade if you can't find people who are skilled in the apprenticeship program elsewhere. Okay, another question. Will the city of Berkeley be required to reimburse the applicant for its attorney fees to sue the city for its denial? Dan, it's a question for you in your case.
I don't know. If you know, maybe you should ask them and let me know. Since that issue is, of course, still pending, I'm not going to address it in any detail, but I will refer back to my earlier response, which is that the Housing Accountability Act especially has very strong provisions to allow the recovery of attorney's fees when you're forced to sue a city to get them to comply with state housing law.
And then Andy, go for it.
I've got another question for Dan and perhaps Nick. The Housing Accountability Act and other provisions that do away with subjective standards. The one I'm thinking of in particular is neighborhood compatibility, which is famously abused in the coastal zone by coastal commission staff and also pops up in other places. I take it that would be a subjective determination of the type that these laws would basically negate in the context of housing. But what is the sort of ongoing viability of subjective design review by municipalities and counties in light of the elimination of this subjectivity and that's reflected in these laws?
I have some thoughts, but I wonder if Shannon does as well.
I'll come off mute. I don't know if this answers you directly, but I will say this is an area that HCD has been working on providing guidance, and we really just released, I think within the last couple of weeks, objective standards toolkits for cities. Cities don't know how to do this. I think there's just a real barrier of understanding about what is objective and how to wrap their head around how to make that work for their locations. So we do have some guidance for local governments on how to create objective standards and put them in place. Absent that, though, there can be a lot of gray area to determine, is this subjective or is this objective? I don't know if that answers the question for you, but it is a tool that HCD has, a problem that HCD is aware of, and a tool to meet that need.
And I'll just add that we may get some useful guidance from the Court of Appeal in the San Mateo case. We thought that project was rejected for a reason that was inarguably a subjective standard. It was a vague guideline about how setbacks ought to be, but it didn't impose any objective standard like height or density. And we did get a trial court that said, close enough, I'm going to call that objective. We think if the law is interpreted to give any effect to its purpose, a standard like that just doesn't qualify as objective. I think we know, for a long time, the legislation just said objective, and we kind of thought people would know what they meant. Or let me go back. The law first said, if you comply with general plan and zoning, you should be approved. And then 10, 20 years go by and you have cities saying, oh, we find you're not consistent with our zoning for a whole raft of reasons that you would never know if you read the zoning, but turns out we interpret our code to require that. So we got the bill amended to add the word objective. We thought that would solve the problem. A couple more years roll by and you have people contending that things are objective that really aren't. Now the bill has a pretty tight definition. It's an item of which involves no personal or subjective judgment and would be known by the developer to read the guideline. I think that's down to things like dwelling units per acre, height. There's all sorts of standards. And cities retain discretion to use their subjective design guidelines to suggest conditions of approval. There's no barrier to that, again, as long as it doesn't deprive the housing of the number of units that it ought to build. But we are going to see continuing fights, and we are going to see continuing developments about, I'll say items that are in the gray area, but to me, I think shade much more towards one end of the color spectrum than the other. Thanks.
One final question in the Q&A, and I encourage everybody to add your questions to the question answer function. There's one more question in here, and I have a few kind of final questions for the group. Does the requirement for prevailing wage in SB 35 include modular construction? Panel, who wants to answer that one?
The statute doesn't say. It says used in the development. But I'm sure we could get a panel of people who will have different opinions about what that entails.
And I'll just add to that, generally under prevailing wage law, offsite work is not considered to be subject to prevailing wage. So Nick is nodding his head, so I think he would probably agree with that.
Yes.
And there's some rationality to that. I mean, no one can certify that every faucet was at its source built by a prevailing wage construction, right? That is not traditionally what we mean when we say that prevailing wage is used in the construction or on the site.
you know, one of the nice things about having 4 attorneys, you get 5 opinions. And so I'm sure this is definitely one of the things that, you know, may be litigated, and the answer to that question can come from that case. Nick, I wanted to turn it over to you to maybe talk about, we know what's these housing bills and these tools that have already been set forth. What's the future? What do you see happening in the state legislature that are going to hopefully provide us some additional tools?
Yeah, I think that's a good question. I'll talk about a few of the things that we are working on now. One is, I want to mention, because we've talked about SB 330, it has a sunset provision, January 1st, 2025. And we have a bill that is going to be extending that for an additional 5 years. You know, we did see a lot of local governments who were trying to resist the implementation of SB 35 to come up with some reasons, including declaring moratoriums until they can come up with their list of objective standards, et cetera. And I've gotten calls about lots of kind of crazy interpretations from different jurisdictions about how this particular project doesn't get to take advantage of that. So there is that. I think providing some maybe more uniformity and easier to determine fee relief than, you know, so that we can see them across the board and have them determinable up front, because certainty is such a big part of being able to plan a project and be able to stick to a plan once you've planned it. And that seems to be a great, you know, certainly a great obstacle to people who are trying to engage in some rational investment strategy. And unfortunately, my involvement with legislation tends to focus on the worst of the worst bills for housing. You know, for some reason, I get the ones where they absolutely have to be killed overnight, to not coin a phrase. So I can tell you that our first rule is do no harm, and there's an awful lot of that. And I would simply say that a lot of the housing bills that are going through today, and for lots of kind of really small housing bills, labor is looming large over those measures as they're going through the legislature, demanding skilled and trained in all kinds of things that will really turn out to make the project infeasible. It makes it very unlikely that these, if they become law, that these laws will be used.
And Nick, thank you for all the work you're doing up in Sacramento. Andy, go for it.
I got a question pretty much for Shannon, I believe. SB 330 has a provision that says where there's sort of incompatibility between zoning and a general plan land use designation for housing density, that the zoning yields to the general plan. And we're now in the process, as Adam mentioned earlier, of this year, especially in Southern California with the SCAG region, huge requirement on the cities, and especially the coastal cities, to upzone, to provide available opportunities for a lot more density and a lot more units. So that's kind of happening this year, where the general plan housing elements are being amended. And I want, you know, just to ask the question, you know, isn't this going to result this year in a situation where a lot of people should be looking to these new housing elements for density opportunities and building opportunities that are protected by this law and facilitated by this law, irrespective of what the you know, sort of slow pokey zoning changes might be down the road?
Yeah, I think that's a good perspective. You know, we require rezoning to occur in the first year. We try to implement programs that require cities to do that, but there could be gaps where the general plan provides for more density than the zoning does. And in that case, that's right, the general plan prevails.
And to follow up on that question, in smaller cities that may not be as adept to these changes, I've seen cities been kind of delayed in updating their housing element. They know there's repercussions, but there's so many cities, and the state's not going to get to them eventually. From a carrot and stick perspective, how can we incentivize cities to actually update their housing elements to meet the RHNA numbers the nice way, and how can we also enforce them to do it the difficult way?
Well, just like the authority we've talked a lot about Housing Accountability Act, and I think our authority over development type projects, there's a whole suite of authority that HCD has over housing element compliance now as well. And monitoring the right implementation of housing elements is also a big part of our work that I really only touched on briefly. So certainly we know, and we've been working with our partners in state government, but there are a number of funding programs that now require housing element compliance for cities to access those funds. If their housing element is out of compliance, which means it could mean they've never submitted it, or it could mean that they've submitted one that is deficient in some way, they will not have access to some of the funding that they may have historically relied upon. So we do hope that that's going to be a stick approach, right, to getting them into compliance. If we find that a city is out of compliance for a long time, we are going to be issuing letters that tell cities that they're out of compliance. And I think that historically HCD hasn't been really great at that. I think we've probably let some cities fester on the back burner for a little while, out of compliance, but maybe not formally out of compliance. And we are certainly reviewing all jurisdictions as they come through. So stay tuned. I think HCD is going to be doing things that are bolder than they have been in the past.
Thanks, Shannon. I believe I don't see any more questions in the Q&A, so I believe this concludes our Q&A session. I want to say thank you to our panelists, Adam, Andy, Shannon, Dan, and Nick. Very informative. I learned a lot. I hope we all gain some new resources that we can use to help solve this housing crisis. I also wanted to thank Diana and BIA and Laura for organizing everything. I told Diana, we need to have a panel on this. I need to understand this better, and the BIA put it all together. So big thank you to everybody at the BIA and all the work that you do. So now I'll turn it over to Diana, the BIA LAB Vice President, for her closing remarks.
Great. Well, we got you guys out of here before our 11:30 time slot, so you get 10-ish minutes back to your day. I learned a lot. I am biased, but I think this is one of the better panels. I think all of you brought so much to it, and I know Hagai already thanked you, but we can't thank you enough. And particularly to Hagai for not only bringing us this idea, but for being such a great moderator. He kept us all on time and asked really valuable questions to kind of keep the panel very thoughtful. So thank you, Hagai. Virtual claps to you. And I'll just say two last things. Don't forget to join us for our PAC Gala next month. It's going to be our first BIASC-wide in-person event. You can sign up on BIASC's website or BIA LAV's events page. That's happening May 13th. It should be really interesting and exciting to get all back together. And then don't forget to sign up for our committees and events also found on BIA LAV's events page. We hope to see you at a committee virtually and hopefully in person soon. Our golf tournament is coming up June 21st, which is only 2 months away. So again, thank you, everybody. We really appreciate you being here and hope to see you soon. Bye.
Thanks very much.